Last night, I read the first 41 pages of the filing from defendant James Finch um, to dismiss the Lynn Haven corruption case. Former Mayor Margo Anderson's attorney also filed a similar filing, all right, to dismiss based on the evidentiary hearings. Hers, though, is not public record, so I'm unable to read it to you. I wish I could. So what's going to happen is the judge will issue a ruling on whether former Mayor Margo Anderson and developer James Finch go to trial or whether it's dismissed based upon prosecutorial, let's say, reckless prosecution. I've been saying malicious prosecution, but I think that's more of an opinion. I think the wording in the document is more reckless prosecution. And I may be splitting hairs. What the judge is going to look at and decide is whether there were Sixth Amendment violations into attorney-client privilege that rise to the level. Also, whether or not the government, the U.S. Attorney's Office, failed to meet court deadlines enough to where that led to problems, whether or not the defense was given all of the evidence, potentially exculpatory evidence in time, whether or not the investigators and the prosecutors gave false statements to the grand jury that were flagrant and false enough times that it rises to the level to warrant dismissal. These are the kinds of things that the judge is going to be considering. So the defense has submitted theirs. The evidentiary hearing that I attended was 3 days long. I attended the last 2 days. That ended almost 4 weeks ago. All right. So now the government will submit its filing. Then the defense, I believe, gets another filing. And then I think probably at the end of this month, more likely in early June, a ruling will be issued by Chief Judge Mark Walker on the case. All right. So I read to you the first 41 pages of James Finch's filing, and it includes evidence that the defense claims warrants dismissal, and it's pretty amazing stuff. I'm going to read to you the rest of it today, all of it, and I'll try to give you context in terms of who's who, because there are a lot of people involved. You may not be aware of exactly, for example, who is Greg Wilson? Why does he play so prominently in this? And so on and so forth. It's amazing stuff. The most incredible part of all of this is that less than 1% of the time, the defense gets to actually see what the prosecutors and the investigators told the grand jury in order to obtain an indictment. In this particular case, there were 3 grand juries because it lasted so long. Each grand jury goes, I think, 6 months. This lasted at least a year and a half. And a grand jury is composed of about 15 to 20 ordinary people. And it's all in secret. You never know who's there. We still don't know. And we don't know what was said. But this is less than 1% of the time are the transcripts actually given to the defendants. And in this case, it's remarkable. And I'm going to read it to you, but I want to start off by thanking 2 of my sponsors, and then I'm going to go right to it.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
It's a hot time in Florida, and my friend Ryan could make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com.
All right, straight to the document. I believe, well, we are for sure. We are on page 42. You can read along with me as we go. All right. Again, this is from James Finch, his defense, asking the judge to dismiss the case based upon essentially reckless prosecution. Here we go. 4. Misconduct before multiple grand juries justifies dismissal with prejudice. The government presented all 3 grand juries with false and misleading information. It further committed vital mistakes of law, causing substantial prejudice. In short, the presentations were fundamentally unfair, violating the due process clause of the Constitution. And while we will concentrate primarily on the last presentation in Pensacola, it is important to consider the government's repeated misconduct in context as the court deems appropriate. All right, this is what the footnote says on that respect. The lead prosecutor committed a host of improprieties before the Tallahassee grand juries, including but not limited to 1, encouraging the grand jurors to help achieve the government's, I don't know what the word is, you can guess. 2, improperly referring to prior indictments, charges, and guilty pleas. 3, failing to give cautionary or limiting instructions as required under the law. 4, failing to provide any legal instructions for conspiracy, honest services fraud, or false testimony. 5, testifying as an unsworn witness. And 6, perpetuating false and misleading narratives about the post-hurricane cleanup, 17th Street ditch, half-cent sales tax, the motorhome transaction, and the design build discussions. In each instance, the presentations were false and misleading. Those are the projects and incidents that are at issue here. The 17th Street ditch, the half-cent sales tax, the motorhome transaction, the design build discussions. All right, everything centers around that. The government's presentation in Pensacola occurred on the afternoon of November 16, 2021. As in all prior grand juries, a single witness testified, guided by the senior prosecutor. At the conclusion of the presentation, the government presented the grand jury with the second superseding indictment, a 58-page, 26-count indictment covering 6.5 years, alleging multiple complex transactions involving dozens of people. Count 1, the lengthy, convoluted conspiracy count, mirrored the conspiracy count in the prior superseding indictment, which the court had previously dismissed as improperly duplicitous. The grand jury further received approximately 60 exhibits amounting to 166 pages of documents. The grand jurors deliberated approximately 120 seconds, voting to return the government's charging document. In context, the proceedings were fundamentally unfair. The defendants were deprived of due process of law. Dismissal with prejudice is warranted. The Fifth Amendment of the United States Constitution provides that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. The grand jury has been characterized as a constitutional fixture in its own right that operates independently of both the judiciary and executive branch. Accordingly, to be valid, the Fifth Amendment requires that an indictment issue from an independent and unbiased grand jury. This requirement has long been recognized. When a motion to dismiss an indictment is based on government misconduct occurring during a grand jury proceeding, the motion will be granted when the misconduct substantially influenced the grand jury's decision to indict, or when there is grave doubt that the decision to indict was free from the substantial influence of such violations, citing case law there. When governmental misconduct occurs in the context of a grand jury proceeding, the proper remedy is to dismiss the indictment. Grave doubt exists in this case. A constitutional violation occurs when the government's conduct is so outrageous that it is fundamentally unfair and shocking to the universal sense of justice mandated by the Due Process Clause of the Fifth Amendment. Such conduct is evaluated under the totality of circumstances. In this case, the violations occurred repeatedly before multiple grand juries, prejudicially spilling over from the earlier presentations into the final presentation in Pensacola. A. Use of false testimony. To establish prosecutorial misconduct for the use of false testimony, a defendant must show that the prosecutor knowingly used false testimony or failed to correct what he subsequently learned was false testimony, and that the falsehood was material, citing case law. There are dozens of instances where the government knowingly or recklessly solicited false testimony from Agent Borghini, the only witness who testified before all three grand juries, including the Pensacola grand jury. 17th Street. False and misleading information was presented to the grand juries, including the Pensacola grand jury, regarding the 17th Street Ditch Project. James Finch adopts and incorporates by reference Defendant Anderson's presentation on Monday, April 4, 2022, regarding the factual inconsistencies between the government's discovery and Agent Borghini's testimony before the grand juries related to the 17th Street Ditch Project. Footnote. Of course, the government finally conceded on November 23, 2021, that Agent Borghini presented inaccurate information about the promissory note before the grand jury number 1 in Tallahassee. Despite this being brought to the government's attention before James Finch was indicted, the government claimed it was only mentioned, quote, some days ago, end quote, and waited 8 months after James Finch was indicted and days after the second superseding indictment was returned to produce this Brady material. Brady material is any material that might be exculpatory that the prosecutor must give to the defense. 2. Half-cent sales tax. False and misleading information was presented to the grand juries, including the Pensacola grand jury, regarding the half-cent sales tax. Finch adopts and incorporates by reference Defendant Anderson's presentation on Monday, April 4, 2022, regarding factual inconsistencies between the government's discovery and Agent Borghini's testimony before the grand juries related to the half-cent sales tax projects. 3. City rebuild and design build potential. False and misleading information was presented to the grand juries, including the Pensacola grand jury, regarding the city rebuild and design build project. Finch adopts and incorporates by reference Defendant Anderson's presentation on Monday, April 4, 2022, regarding the factual inconsistencies between the government's discovery and Agent Borghini's testimony before the grand juries related to the city rebuild. 4. Motorhome. False and misleading information was presented to the grand juries, including the Pensacola grand jury, regarding the motorhome transaction. Finch adopts and incorporates by reference Defendant Anderson's presentation on Wednesday, April 4, probably supposed to say April 4, but it says April 6, 2022, regarding the factual inconsistencies between the government's discovery and Agent Borghini's testimony before the grand juries related to the motorhome transaction. 5. Grand Jury Exhibit 59. The government presented false and inaccurate information within an agent-prepared document to improperly secure an indictment against Finch. On November 16, 2021, Agent Borghini testified about Grand Jury Exhibits 59 DX12. Through leading questions, the agent described the exhibit as, can't tell you because I can't see it. Not only did Agent Borghini's timeline include events unrelated to Finch, but it also included indisputably false information. Within the timeline, the government represented to the Tallahassee and Pensacola grand jurors that Commissioner Barnes, Antonius Barnes of Lynn Haven, seconded and voted in favor of multiple agenda items for the benefit of James Finch, and then received a check for $2,500 the following day. Redaction. So let's look at this footnote before we continue on about Antonius Barnes. Most respectfully, the grand jury should compare the leading questions in the multiple grand jury transcripts with the leading questions by the lead prosecutor during the agent's testimony to the court on April 6, 2022. I was wrong. April 6 is accurate. That would have been Wednesday. Okay. Of the evidentiary hearings almost 4 weeks ago. The defense intentionally did not object to demonstrate the question-answer format employed by the lead assistant U.S. attorney. Virtually every question was violative of form to the point where it is fair to ask who is actually testifying. The same technique was employed in every grand jury presentation. Now back to the claim that Antonius Barnes made the motion or seconded the motion and voted for the motion. All right, that's what we're looking at here. This testimony, they say, is untrue, the defense. These acts did not occur as described on March 14, 2017. The inaccurate timeline was manufactured so that the jurors would believe that a check was written to Antonius Barnes, former commissioner, immediately after Barnes voted in favor of Finch. In truth, Barnes and Finch grew up together. They had been lifelong friends. Barnes had been a commissioner for years prior to these projects. There was no hint of impropriety in their longtime friendship when Finch had prior business with the city. In 2017, Barnes's insurance business needed a small business loan. Rather than going to a bank, Barnes asked his longtime friend for a business loan. As friends often do, Finch agreed. Over the course of several months, Finch wrote his lifelong friend several checks to Barnes's business account, writing loan in the memo section. It was open and notorious and documented. Had Finch wanted to bribe his childhood friend, he could have easily given him cash. He did not. He never denied extending the loan. All the credible evidence demonstrates, and as Barnes repeatedly stated in interviews and on tape during his unrelated bank charge, let's see. I'm going to continue here. Plea, Barnes's business was in financial difficulty. This to me looks like it's continuing on with, I might be messing this up a little bit, but you're still going to see all of it. And you can read it for yourself too. So forgive me if I'm a little convoluted here, or disjointed rather. The events occurred on February 28, 2017. Incredibly, none of the grand juries were presented with any commission meeting agenda or minutes. It's hard to imagine blank, more incomplete, unfair presentation. Plea, Barnes's business was in financial difficulty. According to Barnes, he redacted, it was a small business loan, nothing more. Grand Jury Exhibit 59 was also created to include official acts that had nothing to do with Finch. The February 9, 2016 amendment of resolution to sell property to blank have nothing to do with Finch. This is false and misleading information, was created by the government and improperly presented to multiple grand juries to improperly prejudice Finch, a strategy that clearly worked. B, improper remarks before the grand jury. This is citing case law. A prosecutor is forbidden to make improper suggestions, insinuations, and assertions calculated to mislead the jury and may not appeal to the jury's passion or prejudice. The November 16, 2021 Pensacola grand jury transcript is riddled with leading questions and remarks by the prosecutor that appeal to the jury's passion and prejudice. Within the first minutes of the prosecutor's presentation to the Pensacola grand jury, the government informed the jurors that, redacted, the prosecutor proceeded to inform the jurors that there was already an, redacted. The prosecutor repeatedly asked Agent Borghini leading questions about the prior indictments, charges, and guilty pleas. Just like his testimony at the evidentiary hearing, the agent routinely answered yes and correct. All right, let's go back to this footnote. As the records of the commission meeting demonstrated, Antonius Barnes was not even sitting and did not vote when the 17th Street Ditch project was approved unanimously by the commission. Of course, there is no evidence that Finch received $56 million in fraudulent government contracts. So this is an important one. According to transcripts, the prosecutors told the grand jury that Commissioner Antonius Barnes voted for this and then immediately got payment, or at least implied that he immediately got payment. The defense says that he was not even at that particular meeting. That is demonstrable, right? They can show that. 33, footnote. It is unclear whether the prosecutor's erroneous reference to a blank was intentional, but he also failed to correct his misstatement. We suggest that the jurors were improperly influenced by the prosecutor's representation that the blank Margot Anderson. There were other instances of improper questions throughout the presentation. We respectfully suggest that these types of questions had we respectfully suggest that had these types of questions been asked during trial, objections would have been sustained and the court would have entertained multiple cautionary instructions and likely mistried the case. Of course, the government will argue that it instructed the jurors not to consider the fact that prior grand juries previously acted on this same set of allegations, but that admonition is meaningless in the context of the entire proceeding, citing case law. And of course, we've got a bunch of stuff here that is redacted. Had the prosecutor really intended for the May 16 grand jury to reach its own independent determination without influence as to what another grand jury had done, there would have been no need to even mention the existence of an earlier indictment. The meaningless instruction also does not account for the prosecutor's failures to instruct the jurors that it is improper to consider a determination of guilt as to one defendant as to another defendant's guilt. With the 11th Circuit's special pattern jury instruction, quote, and the fact that a witness has pleaded guilty to an offense isn't evidence of the guilt of any other person. Citing case law, describing the prosecutor's conduct before the grand jury as misdirected and overzealous. More case law, admonishing the prosecutor's use of the indictment process as grossly irresponsible. The prosecutor's repeated references to prior indictments, other charges, and guilty pleas clearly implied to the Pensacola grand jury that it was proper to consider such information as evidence of guilt. These improper references without meaningful corrective or cautionary instructions placed significant pressure upon the grand jury to rubber stamp the indictment out of deference to the prior grand juries. Case law is being cited. Of course, inside of 2 minutes, the Pensacola grand jury did indeed rubber stamp the prosecutor's request. More case law. Finding that the grand jury rubber stamped a superseding indictment after only deliberating for 10 minutes. In Leeper, the grand jury considered the 1 hour of summary testimony for about 10 minutes before issuing the second superseding indictment. The district judge considered the prosecutor's rush through summary testimony and length of jurors' deliberation when concluding that there was a clear violation of the Fifth Amendment. The Leeper district judge noted that the prosecutor hurriedly ran through portions of testimony that had been considered by the original grand jury, often deviating and providing summaries instead of actual testimony. In doing so, the prosecutor in Leeper became an unsworn witness before the grand jury. A similar conclusion is warranted here. Leeper is the name of the winning party in that case. All right, that's what Leeper is. As noted in Leeper, the 11th Circuit vacated its decision. The appeal was later dismissed as moot after the defendant pleaded guilty. Nevertheless, the analysis and reasoning may be helpful as it was to the court in Leeper. The government's grand jury presentation in Pensacola was specifically designed to rush through a complex set of facts that spanned several years. We know this because the prosecutor stated in writing that a fair presentation to a blank, yet the entire presentation took 4 hours. C, improper questions before the grand jury. There are even greater troubling questions and remarks that were elicited by the lead prosecutor during the agent's testimony. For example, the prosecutor solicited testimony from Agent Borghini about Margo Anderson's political platform when running for mayor. Of course, such comments in and of themselves are unfairly prejudicial. Her platform was not to blank, but to bring fiscal responsibility to a city budget run amok. But perhaps the most troubling question occurred toward the end of Agent Borghini's testimony. And that's redacted. The lead prosecutor insinuated that defendant Finch had fraudulently obtained over $56 million in government contracts over 40 years with absolutely no legal or factual basis. Such misconduct was highly prejudicial, inflammatory, and wholly unsupported by any of the record evidence or testimony. And even worse, the lead prosecutor's improper question was not a mistake. It was calculated, planned, and intentional. In fact, he asked the same question before the grand jury in Tallahassee on March 16, 2021, to secure the superseding indictment. That is redacted. When reviewed in its totality, the government's comments, remarks, and improper questions are more flagrant than a few unwitting and inadvertent gestures by the prosecutor, citing case law. The prosecutor's behavior revealed the principal weakness of the grand jury system, the propensity of well-intentioned laymen in the hands of an irresponsible prosecutor to be led down any path. Dismissal with prejudice is warranted. D. Misstatements of law. The misconduct before the Pensacola grand jury also extended to the government's attempts to instruct on the law. Unlike the prior grand juries, where no legal instructions were given to the jurors, even as the complicated honest services fraud counts, the government in Pensacola rushed through what was at best an incomplete set of legal instructions. The rushed presentation fell substantially short of accurately and fully informing the jurors of all required elements of the law and created confusion. Here, the prosecutor began by informing the jurors that he will be providing blank but will blank. Such haste was totally unnecessary. Coupled with the other reckless errors that transpired, an undue influence was wrongly placed on the Pensacola grand jury to return the second superseding indictment without full consideration. Of course, we know that the grand jurors deliberated a mere 2 minutes. Quote, I believe it was similarly short period of time, Your Honor, end quote. The prosecutor's instructions on honest services also served to mislead and confuse the jurors. In fact, the prosecutor described blank, the blank to as, well, you see all that. The prosecutor also provided a pattern jury instruction for conspiracy. The prosecutor also provide a pattern jury instruction for conspiracy. That's how it reads. This is remarkable, of course, since the presentation was being made before the Pensacola grand jury on the second superseding indictment for precisely the reason that it had been presented a legally flawed conspiracy count to multiple prior Tallahassee grand juries. So rather than taking the time to retrieve the pattern jury instruction for a single criminal conspiracy, the prosecutor assumed the jurors had conspiracy cases before and remembered the legal instructions and elements. There is no evidence in the record that the Pensacola grand jury had any prior experience. The prosecutor did not ask whether any jurors had a conspiracy case before, nor did the prosecutor ask whether any juror wanted the government to provide a refresher on the elements of criminal conspiracy. The prosecutor then attempted to summarize the legal elements of a conspiracy charge, but omitted several required elements. Although the prosecutor assumed the jurors were knowledgeable about the necessary elements for a criminal conspiracy charge, he excluded necessary elements of knowledge and performance of an overt act in furtherance of the unlawful agreement. Citing case law here. Conspiracies involve knowing and intentional conduct. They require a meeting of the minds to commit an unlawful act. In total, the prosecutor provided a 2-sentence instruction on the required elements of a single conspiracy count. With all due respect, had this court made these types of errors before a petite jury, most certainly a reversal would ensue. No different result is warranted here. Dismissal with prejudice is the appropriate remedy. A district court may dismiss an indictment obtained in violation of the Constitution or laws of the United States or pursuant to its supervisory power when there is an abuse of the grand jury process, such as perjury or government misconduct, citing case law. Whether derived from the Constitution or from its supervisory authority, this court has the authority to dismiss an indictment where it was issued in violation of the Fifth Amendment's guarantee of an unbiased and independent grand jury. Citing case law, generally a defendant must show prejudice. However, prejudice is not required to be shown if the error has so compromised the structural protections of the grand jury as to render the proceedings fundamentally unfair, in which case there is a presumption of prejudice. Here, the totality of circumstances demonstrates that there is a presumption of prejudice. The factual and legal improprieties, along with the unfair prejudice demonstrated throughout the presentation, improperly affected the grand jury's decision to issue the second superseding indictment. The Pensacola grand jury was most certainly predisposed to indict after hearing these things: false and misleading testimony regarding the 17th Street Ditch Project, false and misleading testimony regarding the half-cent sales tax projects, false and misleading testimony about the possibilities to rebuild under a design-build concept, false and misleading testimony about Grand Jury Exhibit 59, false and misleading testimony about the motorhome transaction, that a prior grand jury, upon hearing the same evidence, had found sufficient probable cause to indict, that others involved in the case had admitted guilt and were cooperating without an instruction that a guilty plea and convictions of other individuals is not evidence of guilt of the accused, improper and inflammatory remarks by the prosecutor that was unsupported by any evidence or testimony, improper prejudicial testimony regarding attorney's fees, improper and prejudicial testimony regarding political platforms and political goals, an improper inference that all of Finch's business in Lynn Haven over 40 years is in the amount of $56 million was fraudulent. The prosecutors would blank instructions of the law. The honest services law was blank. A 2-sentence erroneous instruction regarding the elements for criminal conspiracy. A single witness who admits to providing inaccurate information to a prior grand jury. A single summary witness with no other substantive witness. An agent-prepared timeline that is false and misleading. A slanted, inaccurate way of providing exculpatory information. Other violations, large and small. The totality of circumstances repeat, intentional, fundamentally unfair conduct before the grand jury warrants dismissal with prejudice. Sixth Amendment violation, intrusion of the defense camp. This is super interesting. This one is really, really interesting. And I'm going to continue reading this, and I'm going to finish it. I'm on page 61 out of 76, and we'll continue with it right after this.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
Number 5, Sixth Amendment violation, intrusion into defense camp. Defendant James Finch respectfully submits that the government's conduct in this case is outrageous. It was undertaken with flagrant disregard for his and others' constitutional rights. The government deliberately concealed its unauthorized acts, suppressing evidence until ordered by the court. And when confronted with plain documentary evidence and other corroborated witness testimony, the former agent concealed the truth about the government's misconduct. As a result, lesser relief, as this court might order, including the suppression of evidence, disqualification of government counsel, and the case agent, instructions to the jury, and or dismissal without prejudice will not suffice. The most severe sanction is warranted. A. Basic principles of the Sixth Amendment. The Sixth Amendment right to counsel has been the cornerstone of our criminal justice system since before the adoption of the Constitution and the Bill of Rights. It is a right which time has not eroded because it is fundamental. It is of paramount importance for the simple reason that it is the critical right through which the other rights of the person on trial are secured. Of all the rights that an accused person has, the right to be represented by counsel is by far the most pervasive, for it affects his ability to assert any other rights he might have, citing case law. An adversarial system, however, is subject not to the law of the jungle, but rather is constrained by both the rule of law and rules of professional and ethical conduct. If prosecutors operate under a win at all costs or ends justify the means mentality, they undermine rather than serve the cause of justice, citing case law. Noting that criminal procedure differs from civil litigation because prosecutor operates under an ethical obligation not only to win and zealously to advocate for his client, but also to serve the cause of justice. In a prosecution's interest in a criminal prosecution is not that it shall win the case, but that justice shall be done. For this reason, the Sixth Amendment not only ensures that a defendant will have counsel, but creates a zone of privacy or protection around the relationship, immunizing it from government interference and attack under all but extraordinary circumstances. At the very least, the prosecutor and police have an affirmative obligation not to act in a manner that circumvents and thereby dilutes the protection afforded by the right to counsel. Since privacy is vital to effective representation and to the development of the attorney-client privilege itself, the government is forbidden from eavesdropping or planning agents to hear or disrupt counsels of the defense. Citing case law, the defendant has the right to prepare in secret, seeing and inviting those he deems loyal or those with whom he is willing to risk consultation. The prosecution's secret intrusion offends both the Fifth and the Sixth Amendment. Citing case law, indeed, the principle is well established that surreptitious invasions by the government into meetings between attorneys and their clients or witnesses are forbidden, as is any attempt to stealthily uncover the defense's trial strategy. The conduct of the prosecution team in this case is a violation of the right to counsel that merits dismissal of this case. Citing case law, the Supreme Court invalidated convictions when it was learned that conversations between the defendant and his attorney were overheard through the use of electronic listening devices installed by government agents on the defendant's telephones. The Supreme Court characterized similar conduct as a governmental intrusion of the grossest kind, citing with approval. Citing case law. In Caldwell, the court found a Sixth Amendment violation where a federal agent, while posing as an assistant for the defense counsel, reported frequently to the prosecution on intimate matters of defense trial preparation and strategy. And in Copland, the court found a Sixth Amendment violation where the government agents listened in on telephone conversations between the defendant and her attorney. The 11th Circuit found a Sixth Amendment violation when the government sent an undercover informant to tape record conversations with the defendant. Characterizing as shocking and reversing the defendant's conviction, where a government informant posed as a sham co-defendant and participated in conferences with defendant's attorney and with other defense counsel. To obtain relief for the constitutional violations resulting from the government's invasion of the defense camp, a defendant must show prejudice arising from the invasion. Citing case law, to do so, a defendant need only show that the unlawfully intercepted, but otherwise privileged materials or communications were used in any way to the substantial detriment of the defense. Courts have identified the following factors to consider in determining whether the requisite amount of prejudice needed to establish a Sixth Amendment violation is present. 1, whether the government's intrusion was intentional. 2, whether the prosecution obtained confidential information pertaining to trial preparations and defense strategy as a result of the intrusion. And 3, whether the information obtained produced was used in some other way to the defendant's substantial detriment. In this case, the government's conduct satisfied all the criteria, and the government's repeated and continued concealment of its activities make a narrowly tailored remedy possible. Federal courts must also protect the judicial process from the stigma of illegal or unfair government conduct. Such misconduct can take several forms. The most serious or illegal or unfair government conduct is outrageous, misconduct that shocks the conscience and is also intolerable that it violates the defendant's due process rights under the Fifth Amendment. A district court may dismiss an indictment on the grounds of outrageous government conduct if the conduct amounted to a due process violation. dismissing indictment due to the government's failure to provide defense counsel with material information until the eve of trial. These are all examples of case law that they're citing and standing on. Dismissing indictment due to the government's multiple violations. Dismissing indictment where the government interfered in the attorney-client relationship by using the defendant's former attorney to obtain incriminating information. Even where government misconduct is not sufficiently outrageous to violate due process, the court, under its supervisory powers, may impose various sanctions, including dismissal. Affirming dismissal pursuant to the court's supervisory powers due to the government's violation of discovery obligations and flagrant misrepresentations to the court. Such a sanction is mandated here not only because of the invasion of the sanctity of the defense camp, but because in using a purportedly neutral fact witness to conduct its post-indictment investigation, the government itself introduced incurable taint into these proceedings. Even assuming that an investigation of James Finch post-indictment was appropriate, it obviously was not. The government's ill-advised and unauthorized decision to conduct this investigation under the supervision of the case agent within the operative Wilson, that's Greg Wilson, participating introduced a fatal infection into these proceedings. When I was at the evidentiary hearing, Judge Mark Walker was particularly interested in this right here. Under the circumstances of this case, the appropriate remedy is dismissal with prejudice. Repeated instances of deliberate and flagrant misconduct justify dismissal of the indictment. Court decisions emphasize the unifying premise in all of the supervisory power cases that although the doctrine operates to vindicate a defendant's rights in an individual case, it is designed and invoked primarily to preserve the integrity of the judicial system. The court has particularly stressed the need to use the supervisory power to prevent the federal courts from becoming accomplices to such misconduct. The government's intrusion of the defense camp. B. The government violated the defendants and other represented parties. A represented party is somebody who has a lawyer. Constitutional rights by obtaining communications and information pertaining to trial preparation and trial strategy originating from joint defense group communications between defendants and between defendants and their counsel. In doing so, the government violated standard notions of fundamental fairness that exist for the purpose of keeping the defendant's communication from the prosecution team. The conversations involved in the defense attorney's impressions about the evidence, weakness of the government case, and defense strategy. They included direct and indirect communication with attorneys and the legal work product of the defendants. Instead of instructing former Chief Assistant State Attorney Greg Wilson to avoid all contact with represented parties, including the defendants, Agent Borghini used Greg Wilson to have contact with represented parties and discuss case-related issues. Quote, this is Greg Wilson talking, I was asked to find out about the contents of the box prominently labeled attorney-client privilege, and then later the location. Question, did you know at the time that Derwin White was represented by an attorney? Greg Wilson, I did. Greg Wilson, I know there were occasions that I was directed by Mr. Borghini to specifically find out certain information that I did not know. Question, and did that include meeting with a represented party and questioning them? Greg Wilson, on the two occasions I'm thinking of, one of them was yes. Even more egregious is the fact that the Agent Borghini testified under oath that he never instructed Wilson to do anything with respect to obtaining any information or evidence whatsoever. I watched that testimony in court. Question, and after each of the times you'd met with Greg Wilson, you never told him, listen, go out there and get more information and call me back, did you? Agent Borghini, no. Question, did you tell Mr. Wilson to go out there and get more information, or did you give any instructions about working for you or giving you information? Agent Borghini, I did not. Agent Borghini, I've never directed Greg Wilson to do anything. Question, after May 10 of 2021, Did you hear from Mr. Wilson again before August 26, 2021? Agent Borghini, no. Question. Prior to this date of August 26, were you aware of any box marked attorney-client communications or privilege being in GAC? Agent Borghini, no. Question. And you never told Mr. Wilson to do anything with respect to obtaining any evidence whatsoever. Is that correct? Agent Borghini, that is correct. Let's see what footnote I missed. 27. In addition to introducing Greg Wilson into the defense camp, the government used a grand jury subpoena to gather evidence in an indicted case. All right, let's get back to where we were. With all due respect, says the defense, Agent Borghini's April 6, 2022 testimony, at which I was present, was fabricated. It was demonstrably false. C. Wilson Affidavit, April 21st, 2022, attached hereto as Exhibit 90. On August 5th, 2021, Agent Borghini texted Greg Wilson on the morning the FBI executed a search warrant on GAC's offices and asked, quote, do you know if that grand jury hard drive is still on the site at GAC? Greg Wilson responded that it might be, in a box marked attorney-client communications all over it. Agent Borghini asked, who took out the box and where did it go? To which Greg Wilson, the FBI's informal informant, responded, okay, I'm on it. The only credible inference from the text messages is that Wilson was working for Agent Borghini despite the former agent's contrary testimony. That is certainly what Wilson understood after having signed an immunity agreement with the assistant U.S. attorney, Coons. He was not merely an innocuous random source of information freely provided, providing unprovoked information to Agent Borghini. Agent Borghini said under oath about 4 weeks ago, whenever Mr. Wilson would reach out to me, he'd want to know if I had time to speak. And then if I did, then I would take his call and he would start telling me what he wanted me to know. Footnote. The government's post-hearing production revealed. Post-hearing. This is after the evidentiary hearing. More evidence came in that the judge will be reviewing. This is huge. That post-hearing production of evidence, the text message exchange I just read to you, revealed that Greg Wilson was not the only citizen Agent Borghini was using to collect potentially privileged information on James Finch. On April 8, 2022, the government produced a Bay County Sheriff's Office report prepared by Lieutenant Jeremy Mathis of his May 6, 2021 interview with Commissioner Judy Tinder of Lynn Haven. Major Jimmy Stanford, Bay County Sheriff's Office, was also present for the interview. The report indicates that the agent asked Tinder to keep we don't know what that is, documenting her contact and discussions with James Finch. This was done. Again, this information was not made available to the defense until after the evidentiary hearing, demonstrating that Agent Borghini contacted and solicited information from Wilson. Agent Borghini also further testified that his last communication with Wilson was on August 26, 2021. Question. And your last contact with Wilson was on August 26, 2021. That is correct, he said. But Agent Borghini called Wilson on September 14, 2021, and spoke with him for over 20 minutes. See more evidence, DX90. That is an exhibit. If Agent Borghini would so easily mislead this court regarding his last contact with Wilson, would he hesitate to provide misleading testimony to a grand jury out of the presence of the court? His testimony is simply not credible. He has provided false information before the grand juries and again before this court at the April 6, 2022 evidentiary hearing, says the defense. The Sixth Amendment is violated. 1, when the government intentionally plants an informer in the defense camp. 2, when confidential defense strategy information is disclosed to the prosecution by a government informer. Or 3, when there is no intentional intrusion or disclosure of confidential defense strategy, but a disclosure by a government informer leads to a prejudice the defendant. The government's intentional intrusion into the defense strategy by receiving confidential and privileged information regarding defendants' legal strategy discussions from an informer knowingly placed in the defense camp is reprehensible and shocks the notions of justice. Where the intrusion is intentional, no prejudice need be shown. The defendant's Sixth Amendment right to prepare their case without the intrusion of the government into their defense was irreparably damaged. Additionally, the ultimate interest to be protected is the privacy and confidentiality of the lawyer's work in preparing the case. It is a violation of that interest that is held offensive to the Constitution in the cases of eavesdropping and spying. The protection would be a thin illusion if the government could have, for the asking, what it has, in rare lapses, sought by less genteel means, citing case law. As represented in the hearing as officers of the court, Greg Wilson, participated in the defense strategy discussions with both attorneys representing James Finch, confirming that Greg Wilson was listening to the conversations about James Finch's defense strategy. Footnote: at no point did Assistant U.S. Attorney Coons or Agent Borghini instruct Wilson about the limitations or boundaries related to the informant protected by the attorney-client privilege. Question: this was asked of Agent Borghini. So at any point during this relationship that you had with the government, this is asked to Greg Wilson. So at any point during this relationship that you had with the government, were you given any boundaries about not relating attorney-client privileged information by either the prosecutor or the agent? Greg Wilson: no, we did not have those discussions. Even if Borghini somehow played the Wilson relationship razor thin, which the documents reveal he did not, the level of inherent prejudice in the disclosure of defense strategies to the government is so great so as to warrant dismissal, stated most eloquently by the D.C. Circuit. Moreover, the appellants need not prove that the prosecution actually used the information obtained. The prosecution makes a host of discretionary and judgmental decisions in preparing its case. It would be virtually impossible for an appellate or a court to sort out how any particular piece of information in the possession of the prosecution was consciously or subconsciously factored into each of those decisions. Mere possession by the prosecution of otherwise confidential knowledge about the defense's strategy or position is sufficient in itself to establish detriment to the criminal defendant. Such information is inherently detrimental, unfairly advantages the prosecution, and threatens to subvert the adversary system of criminal justice. Further, once the investigatory arm of the government has obtained information, that information may reasonably be assumed to have been passed on to other government organs responsible for prosecution. Such a presumption merely reflects the normal high level of formal and informal cooperation that exists between the two arms of the executive. And they quote case law. They cite it. It is unequivocally clear, as this comes to a conclusion here. This is the defense's filing from James Finch to dismiss the whole case. It is unequivocally clear that the defense strategies were disclosed to the government and its agent when Greg Wilson, as a government operative, intentionally and surreptitiously acquired knowledge relating to the defense strategies through active participation in joint defense meetings between Derwin White and defendant James Finch. Noting that Wilson is working in Derwin's office and blank, indicating that Wilson would listen to Derwin and Finch talking to each other about things going on, what they heard, what they knew. Confirming that Wilson would provide information to Agent Borghini. Wilson further participated in calls with the undersigned and James Finch. Wilson and the government further learned critical information from speaking directly to Finch while Finch was represented, and to the undersigned, the attorney writing this, in their active representations of Finch. Footnote 31. On June 9, 2020, the lead assistant U.S. attorney announced to the grand jury that his blank, the August 18, 2020 indictment contained criminal allegations related to Derwin White and James Finch, signaling that they were a target of the government. As he did with Margot Anderson, Finch also had a joint defense agreement with Derwin White prior to White's passing. I didn't know that. I read this, but you read it over and then you read it out loud and you see that, wow, okay. The quote, joint defense privilege extends the attorney-client privilege to communications between parties and their attorneys who have a common legal interest with respect to the communication. This is the last page. That's it. After this, we are finished. Defendants Finch and Anderson were deprived of their Sixth Amendment right to counsel when Wilson obtained and shared privileged and confidential information, whether inadvertent or not. The only just remedy is dismissal of the indictment with prejudice. That means, with prejudice means that if the judge dismisses it, it's over. There is no more coming back. Dismissing it without prejudice opens the door to coming back. Conclusion. For the foregoing reasons, defendants' motions to dismiss should be granted and the second superseding indictment should be dismissed with prejudice. Respectfully submitted, Guy Lewis, who is the attorney. Whew. I thought about doing this, a couple of days ago. I knew I wouldn't be able to get through a whole. I looked at the last show was like almost an hour and a half. Whew. Quite a bit of stuff. And as I told you I would do, I did my best to simply read it and to not give my thoughts on it, other than pointing out what I found to be important in the hearings that I attended. So again, what's going to happen now is the prosecutors, they're going to submit their filings. The defense will have a chance to submit another one. And then by the end of May or early June, Chief Judge Mark Walker will decide whether this goes to trial or not. And if it goes to trial, the people brought up as witnesses, the people who the defense bring up as witnesses, to include people in the sheriff's office, the FBI agent himself, it's going to be unbelievable, the things that we will learn. This was very narrowly tailored. There is so much more that they did not talk about that we still don't know. But I will say this. This is my opinion from what I saw. And I'll tell you why. It is my opinion that from what I've seen, the prosecution could come in at trial and give all kinds of incredibly convincing evidence that they are guilty and that a jury would find them guilty. It's possible. That wasn't the place to deliver it at the last at the last evidentiary hearing. But I will say that after the defense presented the stuff I just told you and more, the judge on the last day looked at the prosecutors and said, "Would you like to respond to that?" And they stood up meekly, the prosecutors, and said, "No, Your Honor, we'll submit it in writing." That was remarkable to me. And the things I saw, the evidence I saw, did not support the charges against the two of them. So I will not be surprised if the judge dismisses it completely. I will also not be surprised if it goes to trial. At this point, however, I'm leaning toward the judge will probably dismiss it all. And furthermore, from what I saw, I suspect that the prosecution wants it that way. I don't think the people involved in this investigation and in this prosecution want it to go to trial. I think they did such a terrible job in the evidentiary hearing that they just want the judge to dismiss it so they can blame the judge and say justice was not done. Corruption continues. And corruption does continue throughout Bay County. The people who were guilty in the Lynn Haven case have pleaded guilty, and there are more of them who I believe have committed crimes. You could go get those guys. There are also others throughout Bay County that you could go get that have committed fraud and conspiracy and other corruption crimes that would be so much easier for you to convict. The question is, why aren't you going after them? There's a missing piece to that puzzle. So we'll be keeping a very close eye on this. And I will continue to share with you this information because it's game time, right? It's down to the wire now. And what makes this particularly interesting from our point of view at this point in time is the fact that the judge released the transcripts of what the prosecutors, investigators, and witnesses told the grand juries. That happens less than 1% of the time. And after seeing what I've seen, it should happen 100% of the time. Any defendant indicted and arrested by the federal government should have the transcripts of what was told to the grand jury. That should absolutely be part of any defendant's defense. I hear a lot about how the feds have a 98% conviction rate. Well, that helps when what you tell the grand jury is kept in secret and cannot be used by defendants. That helps. It also helps that most people plead out. I can guarantee you that an actual trial is nowhere near 98%. And if this goes to trial, it will be a doozy. I'll tell you that. It will be a doozy. I want to thank one more sponsor.
Americans for Prosperity is the largest grassroots organization advancing policies that help people improve their lives. AFP Florida seeks to end corporate welfare, expand energy options, and reform education and healthcare by giving people more choices. Sign up today and volunteer at americansforprosperity.org.
If you would like to support my independent efforts, you can do that by becoming a patron. The only reason I can tell you these things and the only reason I can do what I do is thanks to the sponsors and thanks to crowdfunding. People like you who say, here's a tip, Bernie, every month. Here's a tip. Just keep giving us that entree. And you can do that right here by becoming a patron at patreon.com/Bernie Thompson. Patreon.com/Bernie Thompson. As little as $5 a month. It is anonymous, it's easy, and you can quit at any time. Patreon.com/Bernie Thompson. And those of you who support my efforts, I'm grateful, and I do my very best to tell you what you're not going to get anywhere else. Because of my independence and because of my determination. Because when I did work for a radio station, Talk Radio 101, 2014 was my last year after 8.5 years. And they told me that I could not tell you the truth. I told you the truth anyway. And they said, if you keep saying that stuff, we're going to fire you. And I said, you do what you got to do. But I'm not going to carry their water, and I'm not going to lie to you. You can take what I have, but I'm not going to whore myself out. So thank you for letting me do this. All right. And also, as always, thank you to the Unknown Patriot. Yeah, that comes from the Unknown comic. Who remembers the Gong Show? The Unknown Patriot. All right, I'm going to wrap it up. I'll be back with more for you. I don't know when exactly or what exactly, but I can't believe the stuff I'm finding out. And I'll tell you about it when I can. Thank you.